All right, welcome back. So, you know how with the Indian Contract Act, the basic rules seem pretty simple, right? But then you get to the exam and bam, the questions are all about those tricky little details and the exceptions. Well, that's exactly what we're going to break down today.
Okay, so here's the plan. We're going to hit 5 classic exam traps: agreements against public policy, the whole unilateral mistake thing, when past consideration actually works, the privity rule and its big exceptions, and finally, what happens with joint promisors. Let's get right into it.
First up, let's talk about agreements opposed to public policy, all under Section 23. You know, these are the contracts that are basically dead on arrival, the kind the law just won't touch. Let's see what that actually looks like.
So check out this classic exam question. You've got Mr. Rajan, who gives Miss Saritha 2 lakh rupees. Why? To get her to divorce her husband so she can marry him. She takes the cash, gets the divorce, but then, plot twist, she refuses to marry him. So the big question is, can Mr. Rajan get his money back? The real legal issue here is, will a court ever enforce a deal that's meant to break up a marriage?
And this all comes down to a really important legal principle. It's a bit of a mouthful, but it's ex turpi causa non oritur actio. What does that mean? Basically, from a dishonorable cause, no action arises. The courts are not going to help you out if your whole case is based on something immoral or illegal. It's like the whole unclean hands doctrine. You can't ask for justice when you've done something wrong yourself. And here's the key for your exam answer. This is a textbook case for Section 23 of the Indian Contract Act of 1872. It says that any agreement is totally void if its whole point is immoral or goes against public policy. And let's be real, paying someone to get a divorce, yeah, that's pretty much the definition of being against public policy.
So what's the verdict? A big fat no. Rajan can't get that money back. The agreement was void ab initio, void from the very start, because its purpose was against public policy. The court basically just washes its hands of the whole mess.
All right, moving on. Let's get into our second scenario, the unilateral mistake trap. This is all about what happens when only one person messes up. Does that one little error give them a get-out-of-jail-free card for the contract?
Okay, picture this. Mr. Kumar wants to sell his car for $95,000, but whoops, he has a typo in the offer letter and writes $93,000 instead. Mr. Raju sees this great deal and snaps it up, accepting immediately. Now can Kumar just say, hey wait, that was a mistake, and cancel the whole thing?
And the answer lies squarely in Section 22 of the Indian Contract Act. The law is super clear on this. A contract is not voidable just because one party made a mistake. Think about it, right? If you could get out of any deal by just saying, oops, my bad, business would be impossible. This rule is all about creating certainty.
So, the bottom line? Nope, Kumar is stuck. A perfectly valid contract was formed at 93,000 rupees. His unilateral mistake, his one-sided error, doesn't make the contract voidable. He's got to honor the price he wrote down.
Okay, let's talk about consideration. We all had it drilled into our heads, no consideration, no contract. A promise for nothing is just, well, nothing. It's void. But like everything in law, there are some huge exceptions, and Section 25, subsection 2 is one you absolutely need to know.
So, let's set the scene. A's friend, B, has a fire at his house. A, being a good friend, rushes over and helps put it out. He did this totally voluntarily. Later, B is so grateful he says, man, thank you so much, I promise to give you 1,000 rupees for your help. Now the act, putting out the fire, already happened, so is that promise actually enforceable?
This is where we need to see the contrast. On one side, you have a simple promise, like saying you'll donate to an orphanage. That's unenforceable under Section 25 because there's no consideration. But B's promise to A? That's different. It fits perfectly into the exception under Section 25, subsection 2. It's a promise to pay for a past voluntary act, and because of that specific exception, it becomes a totally valid and enforceable contract.
Okay, buckle up because this next one is a huge topic for exams, the privity rule and its exceptions. This is all about who can actually sue on a contract. The basic rules seems easy enough, but the exceptions in Indian law are where the real marks are.
The doctrine of privity of contract is pretty simple at its core. It just means that if you're not a party to the contract, if you're a stranger to it, you can't sue on it, even if the contract was supposed to benefit you. But, and this is a big but, there are some major exceptions. And for your exams, you absolutely have to know these exceptions.
In Indian law, a stranger can sue in certain situations. We're talking about things like family arrangements, marriage settlements, when a trust is created, or, and this is a big one, when there's a provision for maintenance for a female family member during a property partition.
So let's put this to the test. Two brothers are dividing up their family property. In the agreement between them, they both promise to pay their mother an allowance for her maintenance. Now, the mother didn't sign this agreement. She's not a party to it. So what happens if the brothers stop paying? Can she sue them?
Yes, absolutely she can. This is a classic example of the family arrangement exception in action. Even though she's technically a stranger to the contract, it was made for her benefit, and the law carves out an exception to the privity rule to protect her right to that maintenance.
All right, on to our last big topic, joint promisor liability. We're going to unpack what happens when a group of people make a promise together and one of them drops the ball. This is all governed by Section 43.
So here's the problem. P, Q, and R jointly promise to pay Mr. Shetty 60,000 rupees. Simple enough. But then P becomes insolvent, meaning he has no money and can't pay his share. So what happens to Q and R? What are they on the hook for?
Let's do the math on this, step by step. The total debt is $60,000. With 3 people, that's $20,000 each. Now P defaults on his $20,000. Section 43 says that loss has to be shared equally by the remaining solvent promisors. So that $20,000 loss is split between Q and R, which is an extra $10,000 each. So now Q and R's individual liability is their original $20,000 plus that extra $10,000, making it $30,000 each. But wait, and this is the really crucial part for your exam. While Q and R each owe $30,000 between themselves, Mr. Shetty doesn't care about that. He can go after either Q or R and demand the entire remaining 60,000 rupees. That's what joint and several liability means. The person who pays the full amount then has to go and recover the other person's share from them.
And there you have it. This is your ultimate revision cheat sheet. We've got the scenario, the key legal principle, and, most importantly, the governing section for each problem we covered. Seriously, take a screenshot of this. It's going to be super helpful for your last-minute prep.
So that wraps up our look at these 5 killer exam scenarios. The big takeaway here is that in law, it's never just about the main rule, is it? It's always about the exceptions. So here's something to think about. What other standard legal rules can you think of that are totally turned on their head by their exceptions? Keep that curiosity going, and best of luck with your studies.